Yeah, so today we are going to discuss our first topic, that is criminal procedure. So what is criminal procedure? So criminal procedure set forth the rules and regulations that governs the entire criminal proceedings. For example, it starts from the investigation process to final sentencing and identifying the criminal liability, whether the person is criminally liable or not. Now we will look into the definition. According to the Black's Law Dictionary, criminal procedure is the rules governing the mechanism under which the crimes are investigated, prosecuted, adjudicated, and punished, and includes the protection of accused persons and their constitutional rights that are linked to that. Criminal procedure is the adjudication process of the criminal law, while criminal procedure differs dramatically by jurisdiction. The process generally begins with a formal charge with the person on trial, either free on bail or incarcerated. Incarcerated means under custody or under imprisonment. The result in the conviction or acquittal of the defendant. Criminal procedure can either be in form of inquisitorial or adversarial criminal procedure. So there are two types, inquisitorial and adversarial. Types of criminal process are there. The purpose of criminal liability in law serves two important objectives. First, it ensures fairness among all the parties that are engaged in the criminal proceedings. Secondly, it safeguards individual rights to due process and equal protection before the law. Now we will look into the functionaries of the court. Functionaries means the helping hand who are ready to provide help in the criminal procedure that is followed. The criminal justice system in India is a complex framework involving various key functionaries who plays a pivotal role in maintaining law and order, ensuring justice and upholding the rule of law. These functionaries include the police, prosecutor, defense counsel, and prison authorities. The police officer. Functions and organization. The police force is the instrumental in prevention and detention of the crime. Each state government establishes its own police force, which is formally enrolled and consists of varying number of officers and men as determined by the state government. The Director General of Police oversees the entire police administration in a state, while the District Superintendent of Police manages the police administration in each district under the guidance of District Magistrate, usually the Collector of the district, who is a DC. Now we will look into the Police Act of 1861. The Police Act of 1861 establishes the foundation for organization and regulation of police forces in India. This act outlines the constitution of police forces, its powers, duties, and appointment of police officers. Every police officer other than high rank officials like inspectors general receives a certificate granting them the powers, functions, and privileges of police officer, which must be returned if they ceases to hold their position. So they are getting something, delegate authority. Other person are delegating certain powers and they enjoy that much power only. And then other police acts. The Police Act of 1888 allows the central government to create special police districts covering parts of multiple states with the concurrence of concerned state government. The Police Act of 1949 establishes a police force for union territories following the 1861 Act pattern. Then Supreme Court intervention. Reorganization of police has been a persistent issue addressed by various commissions and committees due to inaction from the government. The Supreme Court, in the case of Prakash Singh versus Union of India, issued directives to reform police structure, emphasizing accountability and efficiency. Then Delhi Service Police Establishment Act of 1946. This act led to the creation of a special force for investigation specific offences in union territories and also allows its jurisdiction to extend to other parts of India with state concurrence. The CBI, the Central Bureau of Investigation, established under the Act, often undertakes investigation of significant public interest due to perceived impartiality and interdependence. Then Center Vigilance Commission Act of 2003. To address the corruption, especially at the higher administrative level, the Central Vigilance Commission Act of 2003 reconstituted the Central Vigilance Commission, ensuring its operational autonomy and protection from undue interference. Police power under the code. The BNSS endorsed police officer with specific powers such as arrest, seize, and investigation. The station officer, who is HSO, has extensive responsibility in detecting, investigating, and preventing crime. Superior officers can exercise the same power across the largest jurisdiction, emphasizing the central role of police stations in crime management. Expansion of the power of police officer. The BNSS encompasses police to maintain public order, prevent crime, and conduct investigation while safeguarding citizens for misuse of force, illegal detention, and torture. The Supreme Court has set up guidelines to curb arbitrary use of police power. The BNSS proposes changes to detention procedure and police custody, raising concern. Now we will look into the procedure of the police custody. The CRPC limits police custody to 24 hours. It is extendable to 15 days by the magistrate and further can go to 60 to 90 days for judicial custody depending upon the type of offense. The BNSS propose a fragmented 15 days police custody over 40 to 60 days, potentially complicating bail and custody procedure. Then power of detention amended. BNSS retains the 24 hours protection before the magistrate. However, it adds that a police can detain individual resisting arrest or ignoring such officer's direction. The bill lacks a clear time frame for such detention, calling for guidelines. Use of handcuffs. The BNSS allows for habitual offenders or serious crime suspects. This contradicts Supreme Court's ruling and deeming handcuffs inhumane with judicial consent. Recommendations includes limiting handcuff use of high-risk scenarios. Now, public prosecutors, roles and responsibilities. Public prosecutors represent the state in criminal trial, advocating on benefit of the society against the individual. Their primary duty is to conduct prosecution in session and higher courts. They are also involved in criminal appeals and revisions, providing legal aid to police and other government departments on prosecutional matters. Appointment and qualification. Public prosecutors are appointed under Section 18 of BNSS with eligibility requiring a minimum of 7 years of legal practice. Appointment for High Court and District Court involve consultation with respective High Court authorities and preparation of panel by District Magistrate. Hierarchy and special appointment. Public prosecutor can operate within a hierarchical framework from assistant public prosecutor in magistrate court to PP and additional public prosecutors court in higher courts. The central and the state government can appoint special public prosecutor for specific cases, requiring at least 10 years of legal practice. Independence and reform. The Law Commission's 14th report emphasized the need for separate independent prosecution agency distinct from the police to ensure impartial and effective legal scrutiny. The Supreme Court has reinforced this by disapproving appointments that compromise the independence of prosecution, advocating for a dedicated cadre of prosecutors. Now, Code of Conduct and Ethical Duty. While the BNSS does not explicitly outlines the conducts that is accepted of a prosecutor, the principles are well established. The prosecutors must aim to present all available evidence, whether for or against the accused, ensuring the court can determine the truth impartially. Their role is not to secure the conviction at all costs, but to facilitate justice. Now is defense counsel. Right to defense. Every accused person has the right to be defended by a legal practitioner of their own choice, as per Section 341 of BNS. This right is fundamental to ensure a fair trial, especially under the adversarial legal system where the state prosecutes and the accused must mount a defense. So in India, we follow adversarial system, okay, not inquisitorial system. Then legal aid and indigent accused. Recognizing that many accused persons may lack the means to hire a defense counsel, the BNSS and the Constitution provides for a free legal aid. Section 341 mandates that if an accused in a session trial cannot afford a lawyer, the court must assign one at the state's expenses. The Supreme Court has extended this to the case where the offense could lead to imprisonment, ensuring that no one is denied a fair trial due to poverty. Legal aid schemes. Various schemes provide legal aid, including those by the state government, bar association, and legal aid and advice boards. The Legal Service Authority of 1987 further institutionalizes legal aid, ensuring broad access to legal representation for the needy. Prison authorities and correctional services. This is one of the functionaries of the code. Roles and legal framework. Prison authorities manage the detention of under trial prisoners and the imprisonment of convicted individuals. The Prison Act of 1894 and other relevant laws outlines the establishment, administration, and regulation of prisons. Rehabilitation and probation. The BNSS encourages rehabilitation and probation over imprisonment wherever possible. Section 401 and 420 promote the use of probation for the first time and youthful offenders, directing court to consider non-custodial sentences. Then correctional services. Beyond mere confinement, correctional services aim to rehabilitate the offender, prepare them for reintegration into the society. Various acts such as Probation of Offenders Act of 1958 and Borstal Schools Act support this reformative approach. So I will end the class today here only. We will again start.